Welcome to another episode of Justice for Y'all. I'm Paul Painter, and with me as always is Andrew Bowen. Andrew, how you doing?
I'm doing good, Paul. How you been?
Been good. Spring is in the air. We ready to get out and get on the water.
It is that time of year here in Savannah.
It is. How about you, man? How you been?
I've been good. We've obviously been busy with our practice.
We have.
And we've had a lot of exciting things going on. We talked a little bit about that in our last episode. In this episode, we want to talk about taking a case from intake to an 8-figure verdict.
You're tuned into the podcast where justice meets Southern hospitality, broadcasting directly from Savannah, Georgia, where your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
So, what actually drives case value when we get in a new case?
Yeah, it's a great question because I think it goes back to the saying, the easiest way to get $1 million settlement is settle a $10 million case for $1 million, right?
Right. So, as a practical matter, how do you build a case from intake through litigation, and what actually drives those 7 and 8 figure verdicts?
Right.
And what we found in our practice is that big cases aren't found, they're built. And if you look at any 7 or 8 figure result, whether it's here in Georgia or out in California where we both tried cases, it always traces back to decisions that were made in the case very early on, sometimes at the very first phone call. So here's what we're thinking about. Are you evaluating your cases on what they are today or what they could become with the right development? So first principle that you and I have talked about and we've been working with in our own firm is that intake is not administrative, it's a strategy.
That's exactly right.
So most intake processes are built to qualify a case, get basic demographic information, and does it meet a certain set of criteria, which is important. That's got to be part of the process, certainly. But we also are building our intake process to build the case from the first phone call.
Right, so when that first call comes in, we have our criteria of does it meet our basic qualifications for a case, but then are there some things in that case that make it jump out that say this is not your everyday case, this is a potential 8-figure case.
Right, and that's a good point. Not every case is going to be turned from a fender bender into a 7 or 8 figure case. Some cases are just what they are. We say often, I've heard you say it as recently as yesterday, we don't make the facts.
Right.
Now we can develop the facts and build them, but we don't make the facts. So some cases just are what they are. But what we're looking for to see whether a case from the very first phone call has a potential to be developed into a big case is liability clarity.
Right.
That's important. The damages potential of the case, and then of course coverage or otherwise deep pockets for the case.
I say, I love the way you say it with the damages potential, because that's the thing when a case first comes in the door that is the most difficult thing to sometimes evaluate. Obviously, if you have a wrongful death case, that's sort of thing, or a clearly catastrophic injury on day one, then those things jump out. Anybody can recognize that. But what is sometimes not seen is this the type of injury that is going to have a catastrophic effect on the person over years and years and for a lifetime, and has the potential to really damage, if not destroy, a family's life as they knew it. And those things can be obvious, but I think what we're talking about here are the ones that aren't as clear. And the thing that jumps out to me as maybe the most common thing are brain injuries. Because brain injuries are one of those things that the people who experience them don't necessarily recognize that's happened to them. And they are shockingly undiagnosed across the country throughout the medical community. I think that's getting a little better, but that's a real issue that we try to screen for when we talk to people who have been in particularly pretty bad wrecks, something with bad damage, or there's a lot of force transfer, that kind of thing, or have a fall where someone's hit their head, or any kind of experience like that, because you can do it most commonly if someone's married asking their spouse. saying, are they, moodier than they used to be? Are they more forgetful? What are some symptoms you're seeing? Sometimes you have irregular eye movements called saccades, and that's a big red flag that there's something going on, and it's not just a hurt neck or a hurt back, not to minimize those, because those can be terrible in themselves, but that's one of those things.
And there are several different ways to objectively evaluate these kinds of brain injuries. Saccades is one of them. That's an objective finding,
Right.
As opposed to somebody just saying, yeah, I'm fuzzy-headed and I can't remember things as well as I used to, or my personality's changed. There's also really new and innovative imaging that can look at inside the brain at a very microscopic level and map out broken connections within the brain.
Yeah.
So finding that out early for your potential damages lets us go ahead and get the proper testing, get the proper treating physicians on board, get the proper experts on board from the very first time we open the file.
100%. And you start talking about the scans that can be done now. We really need to have an episode, or probably a series of episodes, on recognizing and proving brain injuries, just as an aside. But that's the thing that we see the most obvious that is not caught necessarily medically or by other law firms that we just happen to learn a lot about.
Write that down. That's a good episode.
Will do.
So, for the audience, think of a sort of newish case in your office right now. What story could you tell about that case today without any additional work? And if the answer is, well, not a real clear one, I don't have a real clear story, that doesn't mean it's a bad case. Mm-hmm. It just means that you've got to get started with the real work. So, oftentimes, just practically, for example, police reports are wrong sometimes, or they're incomplete. And so we've got to go out and find witnesses and get witness statements and go to the intersection and get pictures and see what it actually looked like, for example. And another thing is when a case first comes in that can take it from potential to reality as far as the value is that, a lot of times the client comes in and they know something happened to them, but they haven't found their voice yet. They don't know how to tell their story in a way that's going to connect with and be compelling to a jury.
And let's take those one at a time, because you're talking about working up the case with early evidence, right? And some examples of that, before we get to the client's story even, is you got to send an investigation out often quickly if it's not otherwise been put together. So we like to get a case in the door as soon after it happened as possible, because let's say it's a tractor trailer wreck, it's sort of the one that jumps out the most. If you have that, you want to get an expert out to the scene before the tire marks and the other physical evidence at the scene have gone away. If you have the State Patrol, the STIRT team, or MATE team, depending on your state, has been out there and they've put markings on the road, it should have been well documented, but you'd like your expert to go out there and take another look and see what is happening there.
And you know who is going to be out there, whether you do it or not?
The defense lawyer.
That's
and
right.
Defense as a team out there, usually the day of. So you want to do that. You want to go see, there's so many recording devices, video recording devices in the world nowadays, Ring cameras and that sort of thing, that especially if you are in a urban area, the event was recorded. I mean, there are so many cameras out there that if you just go out there and you start looking for the cameras, you're going to be able to find them. The police do this sometimes, and that's great when they do, but it's not always done. And the
I
problem
would say it's usually not done,
Yeah.
unless it's a major accident with potential criminal charges.
right. And so you want to, and the problem with that is the videos, they're getting to the point now where you can keep them longer, but traditionally you've got maybe 2 weeks, maybe a month before they're recorded over, or they just don't keep the data much longer than that. So you got to hit the ground running on these things. And like you say, witnesses, getting witness statements, witness affidavits quickly before the witnesses go to the, go off and leave town or whatever they're going to do.
We live in a community, an area with multiple military bases.
Right.
Your witness may be deployed overseas and you're not going to see them for 2 years.
Yeah.
So, getting this early evidence really wins cases and helps you make sure that a significant case receives significant value at the end of the day. So within days, you need to be thinking about your preservation letters. You need to do the scene inspection. You need to track down witnesses that you can. You need to be getting vehicle downloads.
Right.
You need to be requesting any incident reports, you can't always get them, but if there's an accident, there's going to be an incident report.
Yep.
Most of the time.
And the dash cam, body cam from officers investigating the scene, that kind of thing. If there's not a criminal investigation, you should be able to get those pretty quickly. And that will often drive where that early investigation goes too, because then you have an idea of what's there, and you may see witnesses, you may see things that you got to look further into.
Yeah.
I'll give an example of that just to can show the difference. We had a tractor trailer wreck case a few years ago now, but it came into his pre-suit, and the insurance company for the truck was denying liability. And it was a very complicated wreck. There were several vehicles involved. It wasn't obvious if you look at it that the tractor trailer was the wrong doing vehicle, and then I think even the police report maybe not blame the tractor trailer, but we got all the dash cams and the body cams and all the information and went through it meticulously, found all the witnesses, tracked them down, talked to all the witnesses, and when we put it all together and put a timeline together, it showed that the truck was the real cause, the start of the wreck. And we also were able to figure out that the brakes on the truck had gone bad, one of them was frozen up, and the way that it froze up, something about this had to do with changing lanes, would have pulled the truck from one lane to the next, which was a key fact in proving liability. And once we worked all that up, we sent the man letter and they paid $1 million after denying liability.
Right.
So that kind of thing can make, we're talking about making a 7-figure case, an 8-figure case, but it can also make a zero offer case into a policy holders case.
100%. And we've seen cases, been involved in cases where maybe we came in late to the case where that witness is missing, or the scene has changed and we didn't get the scene investigation we would have liked. And you can still try those cases.
Sure.
But it's a lot harder. You're doing it the hard way when you have to do that. Well,
what about client? The other thing you've talked about is the client's voice. So
yes.
Why don't you talk a little bit about what you mean by that? Because that's really important. Of when you first talk to the client, you may think, it doesn't really sound very compelling. But let's talk about how that can change.
Yeah, there are a couple of clients that I'm thinking of right now. A couple types of clients that, as lawyers, we have to work with them to get them to be able to tell their story. The first one is the stoic client. The client who is hurt and maybe badly hurt, but they're stoic to the point where they just don't know how to talk about how they're hurting, and getting a middle-aged man with that demeanor to open up about how these things have really affected him. Mm-hmm. It can be a hard thing to do, and a lot of times you have to spend a lot of time just in one-on-one conversation with that client to get him to open up to you, and then be able to prompt him how to open up to a jury. And sometimes you can't do it. Sometimes you have to tell that story through his loved ones. Mm-hmm. So you have to get to know the wife, the kids, the next door neighbor, that sort of thing, if that's the kind of client you're dealing with.
And I think just to further clarify what you're saying is you're not talking about taking a stoic 50-year-old man and making him cry on the stand. That's not going to look right. Nobody's going to. It just doesn't fit, right? I mean, they still need to be themselves. But what you're talking about is the stories that they have about how this has affected their life, and getting to know your client and having that level of trust and that ability for the client to open up to you and tell you can make the difference. Because every once in a while you'll get a story, and I wish I had one I could bring to mind right now. I didn't think about this ahead of time, but it'll happen that the client will just sort of mention something that happened to them, and you realize, oh my God, that is so powerful.
Right.
Like that just changes the entire case, that one story alone.
Yeah. We've had a mother of young children who was somewhat stoic, But one of the stories she told us is that she had recently gone with her family to Disneyland, Disney World in Orlando. And, you know, she's a 38-year-old woman with young kids, and she's talked about how she had to ride the electric scooter around. And that's a totally different experience. That's a something that really showed that she wasn't able to enjoy being with her family on what should have been a magical day, no pun intended with the magic kingdom. And this injury interfered with that. And so that became a central part of our damages story, is talking about that story and having her tell that story.
And I think one thing that I'll interject is I think a lot of people listening, I'm sure, have the defense will bring up that, oh, your client's fine, they were going on vacation. Well, you have a story like that, it flips that narrative.
Yeah.
It flips your client's fine, they're going on this vacation to, I couldn't go on the rides with them because I'm sitting here stuck in this, mobilized chair, and, my loved ones having to, in this case, my husband maybe having to do everything, and, the kids are not getting this experience. That's something I've been dreaming about doing, is you take your kids to Disney, and as big of a pain it is, it's part of the American family experience that now she didn't fully appreciate.
On the flip side, you do get to the front of the lines.
Yeah, you gotta be careful with these things, right? It's not a total sob story, but the point is, those are the things you gotta get out to tell the full story, to make it both relatable, and really understand how the injuries in your case changed your client's life, which goes to a point that we were talking about beforehand. If you have a case where someone broke their pinky finger and it had to get fused together, well, for most of the population, that's the case, sure, but it's not going to be a major case, right? What if that person was a classical pianist, and that is how they made their living, or perhaps that is their ambition in life? Well, that may have just totally obliterated that person's chance of doing that. I'm not sure if it would or not, but I'm just saying,
right,
that kind of example. So getting to know your clients and understanding who they are and their full story helps you unlock their story and what the damages really are.
And one more comment on that before we move to our what I want to talk about next, is telling the damages story in stories is much more effective and connects much more than just simply saying, well, my shoulder hurts when I lift it above X level. That's an important fact, but just saying that doesn't connect with the jury nearly as much as talking about the stories of how it's affected your life.
Right. And one more thing on this, I'm sorry, this is such an important thing, but we spend a lot of time with our clients before trial helping them to tell their stories. And it makes a huge difference. We videotape them, and we go about showing them how they appear. And one of the things is emotional congruence. That's a shout out to the old Trojan horse.
That's right.
But it is the idea of, if you go through a traumatic event, an emotional event, retelling the story as if you're there and reliving it in your mind's eye is extremely powerful, because what do they say, 90% of communication is nonverbal. So if you have, you can see in somebody's facial expressions and their body language when they're happy and sad and otherwise. And if you just try to tell your story factually, it's going to sound pretty clinical. And and you're not communicating, this is everybody, but you're not communicating what actually happened, where the words don't have to be perfect for the client, but the client is communicating through their expressions and through their mind's eye reliving it. They can really be powerful witnesses in ways that you never thought they could be powerful witnesses in the way they told the story before. So there's a whole science to it.
There is. I mean, for example, think of your friend who's the best storyteller you know, and think about when they tell a story. Usually they're going to be telling that story in present tense. Like, oh man, you're not going to believe what happened to me yesterday. So I'm sitting in the coffee shop, and I'm just sitting there drinking my coffee, and this guy walks in, and he's got this wild hairdo, and he just reeks a pot, and that's that's how people tell stories when they're talking to their friends.
And for those who are not watching this on YouTube, what Andrew was doing right then is giving hand gestures about each part of that. I was sitting there drinking my coffee. He kind of does a drinking gesture, just the way a normal person would.
And it's not
And then
conscious.
and then somebody comes in the door, he uses the other hand. So he's visualizing it, and I'm watching him.
And you can visualize.
And I'm visualizing, like I'm picturing you in the chair. I see that he's coming from left to right. And then you have you put your hands out and he reeks a pot. I'm like, okay, he really reeks a pot. I can see the cloud almost going around him. So,
Right.
anyway, there's a whole science to it that we spend a lot of time on.
Yeah, we try to get our clients to put themselves back in the situation and be able to tell the story in that present tense mind frame. And just telling it as they see it in their mind's eye, not reciting A happened, then B happened.
To close this out, I mean, I think what we've heard from trial lawyers we respect very much, and I think agree with this, that there are basically three elements to a big case. You obviously have to have the damages. There has to be significant damages there and ability to pay. But the other two are, you have to have a villain. Basically, you have to have somebody with the defendant who is not likable. I mean, has done something wrong, and that you can say this is the villain of the story, not just somebody who made a mistake.
Yeah.
Just making a mistake will drive down damages. If somebody is really a villain,
And you can still get good value for cases without a villain, but
right.
it certainly pours a little gasoline on the fire if you have one.
Exactly. And then what's the saying? It's not a likable client. It's a like affable client. I forget what the word is, but it's something that you don't necessarily have to like the plaintiff. But the plaintiff appealing, there has to be an appealing plaintiff. There has to appeal to someone's senses in some way.
Yeah.
Now, likability is great, but I will tell you from all the cases that we've gotten big verdicts on, the clients were fantastic. The clients were the star of the show. And the jury sees that. And that makes a difference. And you know, we lawyers can arrange, we can arrange the circus, but we're not actually in it, really, at the end of the day. And so that makes a huge difference. And that way, when you have that intake and you evaluate your client, and you're like, this is a great client, that's your big case. If it's the same exact thing and you've got kind of a dirtbag as a client, doesn't mean they don't have value, but that's not the one that's going to go from 7 figures to 8 figures. It just isn't.
Right. And you know, that's not something that as a lawyer you can necessarily change.
Yeah.
Now, you know, sometimes you can work with clients and teach them how to find a voice that is appealing.
Yeah.
So something else I've been thinking about, Paul, is in medical, think about big medical bills.
Right.
Now, obviously, it always is a benefit to your case if your client has had a lot of serious medical treatment and the medical bills are significant. Certainly, that's a big factor in getting cases settled. Insurance adjusters, that's one of the primary things they look at. How much are the bills? They're also looking to see how much of the bills they can carve out by saying they're unreasonable or what have you. But there's a difference between a case that sounds expensive because it's got a lot of high medical bills and a case that feels real to a jury. Mm-hmm. Jurors don't necessarily always respond just to big numbers. They respond to something, a believable harm. It's the harms that really connect to jurors to get a big verdict.
Exactly right. And just as a most obvious example I have, that $21 million verdict we got in California last year, we didn't put in the past medical bills. The past medical bills were not big. They had some confusion due to the way the treatment played out, so we didn't claim them. And obviously the jury didn't care about that.
Yeah. Because they connected with the real harm to our clients.
What's happened to the people? How's it changed their life? I think that just goes to an overarching idea of most people, rightly so, representing clients, need, if they can get the case settled, or their audience is the insurance company. How do we build this case so the insurance company will have the most value to it? And that's fine. I mean, you got to do that. You can't ignore that. If
this is a both and, not either or.
Right. Yeah, you got to give most clients do not want to go to trial. You got to give their case a chance. But preparing the case for trial, you have a different audience. And so it's important to maybe 90% of your cases that aren't going to trial or more suddenly becomes important. And that is, what are the actual damages? How are real people going to see this who are not insurance adjusters?
Right.
Because sometimes those big numbers of a medical bill, if there's $1 million in medical bills, that jumps out to say, oh my goodness, somebody was really hurt. But let's go back to our brain injury discussion. even though that we now have some scans that are very helpful for that, there's very limited medical intervention that can be done, even for a fairly serious brain injury, unless you have total treatment for someone who is, incapacitated, right. But if people can live on their own, their medical bills are not going to be big,
Right.
and they're not going to be big long term, for the most part. I mean, you can put life care plans together, but they always get a little. We have a whole episode on life care plans another time. But
Yeah, but short version is life care plans can be overdone if it's not a real serious injury that's going to have serious treatment going forward. Life care plan doesn't really hit.
No, and it's going to lose your credibility. You have real injuries, and then you're like, yeah, it's $1 billion life care plan. The jury's going to be like, I don't think they're going to need every one of those little things you're asking.
So with what you're talking about, with real harm, real injuries, you still got to make that connect with the jury.
Right.
And in my mind, there's sort of three ways that can happen. One, your client, going back to the stoic client as an example, you've got to have a client, hopefully, that can tell their story. Ideally, you have treating physicians who you can trust to talk about the injury, but that's not always the case. Sometimes treating physicians don't want to be involved, or sometimes they're just not a good witness. You may have to hire an expert specifically just to talk about your client's injury and the ways, the significance of it and the way it affects the client. And then, of course, as a lawyer, it's part of our job is to tell that story. If you can do that, if you can make the jury really appreciate that this person was hurt and hurt significantly, and it is affecting their life, that's when a case can go from moderate value to a high value case. Another way, or another aspect of taking a case from okay value case to a high value 7 or 8 figure case is being ready for trial.
Okay.
Being ready for trial changes everything. I mean, it's not for nothing that everybody talks about cases aren't going to settle till they're on the courthouse steps, until a trial date is set. Those pressure points really tend to get cases settled. And to do that, you got to be ready. And you've got to work up the case from day one as if it's going to trial. And I don't know if this is a secret or not. If it is, it's not a well-kept secret. But the insurance companies are not just evaluating the case, they're evaluating the lawyers who are bringing the case.
Right.
And they know, are these guys going to work up this case? Are they going to take it to trial? Or are they not?
And if they take it to trial, are they going to win? I mean,
right.
Just taking it to trial and being able to do that adds value to your case, because there are some people who they know will not go to trial, and they're not going to get rated as highly. Those who take it to trial will get rated higher. It's like, well, we got to go through trial. But those who take it to trial and win regularly have the highest rating.
The math changes.
Yeah, that's what, talking to some insurance adjusters or former insurance adjusters, that's what they convey. So,
here's sort of to sum it up. Increasing your case value starts on day one. Mm-hmm. And the earlier you get the right strategy in place, the more control you're going to have, and the more you're going to be able to drive the value of your case. Sometimes that means bringing in the right co-counsel early, not because you can't do it, and not because the case isn't good, but because the potential for the case to be great is there. And it can be as simply as a matter of sharing resources, or a different expertise, different area of practice, or just trial experience.
And to that point, we practice what we preach here. I mean, the way we have our practice set up is, if the case is, the realistic value is going to be $1 million or less, certainly, but even up to maybe $1.5 million. That is something that one lawyer and one paralegal can usually handle with a second lawyer assigned. If it gets up to multi-million dollars and certainly get to 8 figures, we're going to have a team on it, because it takes that much more. It deserves that much more. And you start having some subspecialties, because there is a difference between litigating a 6-figure case and a high 7, 8-figure case. There just is. It tries different. The issues become different. The appellate considerations become different.
The behavior of the defendants becomes different.
The behavior of the defendants, that's shocking for those who go into it. you really see those differences. And
I'll say this, it's not, we don't only get brought into cases, we bring other lawyers into cases. Sometimes
Sure.
it's to share, expenses on a particularly complex medical malpractice case with 5 doctor defendants and, the expert and travel and all that is going to be expensive and logistically difficult. So, we do it both ways.
or somebody's got an expertise in some area that we're looking at and say, hey, I think that'd be a good fit for the client. And, we find people we like to work with too.
Yeah, that's right.
It makes us better lawyers to work with other good lawyers, I think.
Yeah.
And it may be one of the biggest drivers of making us the lawyers we are today, the people we've had a chance to work with and learn from.
100%. All right, well, that kind of wraps it up for today. But before we go, you want to hear a joke?
I don't, but you're going to make it.
So what do you call a dinosaur police officer?
What's that?
A triceracop. All right, thank you, everybody.
All right, bye-bye.
Talk to you soon.
Thanks for listening to Justice for Y'all. If today's episode resonated with you, or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that we're committed to justice for y'all.